If you believe that your right to fair housing has been violated, you can file a complaint with the Maryland Commission on Civil Rights. The Maryland Commission on Civil Rights, or MCCR, represents the interest of the state to ensure equal opportunity for all through enforcement of Titles 20 of the State Government Article and 19 of the State Procurement and Finance Article, Annotated Code of Maryland. MCCR investigates complaints of discrimination in employment, housing, public accommodations, and the state's commercial non-discrimination policy from members of protected classes that are covered under those laws. What is a protected class? Maryland's housing discrimination laws make it illegal to treat a person differently due to their membership in any of the following protected classes: race, color, religion, sex, familial status, national origin, marital status, sexual orientation, gender identity, disability, or source of income. What are some examples of housing discrimination? MCCR works on behalf of the citizens of Maryland to ensure that housing providers are complying with state laws and to ensure that every Marylander is able to access housing free from unlawful discrimination. In the state of Maryland, it is illegal to refuse to rent a dwelling to any qualified buyer or renter, use discriminatory terms and conditions in selling or renting, set terms and conditions of home loans in such a way as to discriminate, use discriminatory notices or advertisements indicating a preference or discriminatory limitations, say that a dwelling is not available for inspection, sale, or rent when in fact it is, attempt to steer persons into or away from neighborhoods or apartment complexes due to being members of a protected class, request information about birth control and or family planning practices, refuse to consider both applicants' incomes when seeking to buy or rent, commit acts of prejudice, violence, harassment, intimidation, or abuse directed against families or individuals or their residential property. Disability and reasonable accommodations. A disability is a physical or mental impairment that substantially limits one or more major life activities. While some impairments may seem invisible, others can be readily observed. Observable impairments include blindness or low vision, deafness or being hard of hearing, mobility limitations, and other types of impairments with observable symptoms or effects, such as intellectual impairments, including some types of autism, neurological impairments, for example, stroke, Parkinson's disease, cerebral palsy, epilepsy, or brain injury, mental illness, or other diseases or conditions that affect major life activities or bodily functions. If you have a disability, you are protected under the law. It is against the law to refuse to permit or at the expense of the renter reasonable house modifications that are necessary for the daily life of a person with a mental or physical disability. Refuse to reasonably accommodate or adjust rules, policies, services, or practices that hamper the use of an apartment, condominium, or house by a person with a physical or mental disability. Have multifamily housing that is not accessible to people with disabilities. Multifamily housing is required to have accessible units and access routes, wide doors and hallways, accessible public and common areas, and management must provide for effective communication as needed by a disabled person. A requested accommodation or modification may be necessary when there is an identifiable relationship or nexus between the requested accommodation or modification and the individual's disability. Reasonable accommodations. A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces, or to fulfill their program obligations. Any change in the way things are customarily done that enables a person with disabilities to enjoy housing opportunities or to meet program requirements is a reasonable accommodation. In other words, reasonable accommodations eliminate barriers that prevent persons with disabilities from fully participating in housing opportunities, including both private housing and in federally assisted programs or activities. Housing providers may not require persons with disabilities to pay extra fees or deposits or place any other special conditions or requirements as a condition of receiving a reasonable accommodation. Since rules, policies, practices, and services may have a different effect on persons with disabilities than on other persons, treating persons with disabilities exactly the same as others will sometimes deny persons with disabilities an equal opportunity to enjoy a dwelling or participate in a program. Not all persons with disabilities will have a need to request a reasonable accommodation. However, all persons with disabilities have a right to request or be provided a reasonable accommodation at any time. Reasonable modifications. A reasonable modification is a structural change made to existing premises, occupied or to be occupied by a person with a disability in order to afford such person full enjoyment of the premises. Reasonable modifications can include structural changes to interiors and exteriors of dwellings and to common and public use areas. Examples include the installation of a ramp into a building, lowering the entry threshold of a unit, or the installation of grab bars in a bathroom. Prohibited discrimination includes a refusal to permit, at the expense of the person with a disability, reasonable modifications of existing premises occupied or to be occupied by such person if such modifications may be necessary to afford such person full enjoyment of the premises. A provider has an obligation to provide prompt responses to reasonable accommodation requests. An undue delay in responding to a reasonable accommodation request may be deemed to be a failure to provide a reasonable accommodation. Examples of reasonable accommodations and modifications include, but are not limited to, assigning an accessible parking space for a person with a mobility impairment, permitting a tenant to transfer to a ground floor unit, adjusting a rent payment schedule to accommodate when an individual receives income assistance, adding a grab bar to a tenant's bathroom, permitting an applicant to submit a housing application via a different means, permitting an assistance animal in a no-pets building for a person who is deaf, blind, has seizures, or has a mental disability. The requirement to provide reasonable accommodations and modifications applies to, but is not limited to, individuals, corporations, associations, and others involved in the provision of housing or residential lending, including property owners, housing managers, homeowners and condominium associations, lenders, real estate agents, and brokerage services. What information may a provider seek when a reasonable accommodation or modification is requested? A provider is entitled to obtain information that is necessary to evaluate if a requested reasonable accommodation or modification may be necessary because of a disability. If a person's disability is obvious, readily apparent, or otherwise known to the provider, and if the need for the requested accommodation or modification is also readily apparent or known, then the provider may not request any additional information. If the disability and/or the disability-related need for the requested accommodation or modification is not known or obvious, the provider may request only information that is necessary to evaluate the disability and/or disability-related need for the accommodation. This information may be from the requesting individual, medical professional, a peer support group, a non-medical service agency, or a reliable third party who is in a position to know about the individual's disability. In most cases, an individual's medical records or detailed information about the nature of a person's disability is not necessary for this inquiry and may be inappropriate. When may a housing provider deny a requested accommodation or modification? A housing provider can deny a request for a reasonable accommodation or modification if the request was not made by or on behalf of a person with a disability, or if there is no disability-related need for the accommodation or modification. In addition, a request for a reasonable accommodation or modification may be denied if providing the accommodation or modification would impose an undue financial and administrative burden on the housing provider, or it would fundamentally alter the nature of the housing provider's program. The determination of undue financial and administrative burden must be made on a case-by-case basis involving various factors. The interactive process. When a housing provider denies a requested accommodation or modification, the provider should discuss with the requester whether there is an alternative accommodation or modification that would effectively address the requester's disability-related needs without a fundamental alteration to the provider's operations and without imposing an undue financial and administrative burden. As part of this interactive process, the housing provider should recognize that the individual requesting the accommodation or modification is most familiar with his or her disability and is in the best position to determine what type of aid or service will be effective to meet a disability-related need. These discussions often result in an effective accommodation or modification for the requester that does not pose an undue financial and administrative burden for the provider. Assistance animals. One common request housing providers receive is for a reasonable accommodation to providers' pets or no animal policies so that individuals with disabilities are permitted to use assistance animals in housing, including public and common use areas. Assistance animals are not pets. They are animals that do work, perform tasks, assist, and/or provide therapeutic emotional support for individuals with disabilities. There are two types of assistance animals. 1. Service animals, and 2. Other animals that do work, perform tasks, provide assistance, and/or provide therapeutic emotional support for individuals with disabilities, also referred to as a support animal. An animal that does not qualify as a service animal or other type of assistance animal is a pet for purposes of the FHA and may be treated as a pet for purposes of the lease and the housing provider's rules and policies. A housing provider may exclude or charge a fee or deposit for pets in its discretion and subject to local law, but not for service animals or other assistance animals. What is a service animal? Under the ADA, service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, and other mental disability. Other species of animals, whether wild or domestic, trained or untrained, are not service animals for the purposes of this definition. The work or tasks performed by a service animal must be directly related to the individual's disability. What is an assistance animal? An assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or that provides emotional support that alleviates one or more identified effects of a person's disability. An assistance animal is not a pet. Sexual harassment. Maryland's anti-discrimination laws prohibit sexual harassment. There are two main types of sexual harassment. 1. Quid pro quo sexual harassment, and 2. Hostile environment sexual harassment. Quid pro quo. Quid pro quo harassment occurs when a housing provider requires a person to submit to an unwelcome request to engage in sexual conduct as a condition of obtaining or maintaining housing or housing-related services. For example, a landlord tells an applicant he won't rent her apartment unless she has sex with him. A property manager evicts a tenant after she refuses to perform sexual acts. A maintenance man refuses to make repairs unless a tenant gives him nude photos of herself. Hostile environment. Hostile environment harassment occurs when a housing provider subjects a person to severe or pervasive unwelcome sexual conduct that interferes with the sale, rental, availability, or terms, conditions, or privileges of housing or housing-related services, including financing. For example, a landlord subjects a tenant to severe or pervasive unwelcome touching, kissing, or groping. A property manager makes severe or pervasive unwelcome, lewd comments about a tenant's body. A maintenance man sends a tenant severe or pervasive unwelcome, sexually suggestive texts and enters her apartment without invitation or permission. Retaliation. It is illegal to retaliate against any person for making a complaint, testifying, assisting, or participating in any manner in a proceeding under MCCR's complaint process at any time, even after the investigation has been completed. If you believe you have experienced retaliation, you can file a complaint. Filing a complaint. The intake unit, which is a part of the case processing department, is ready to assist you if you believe you are a victim of discrimination and wish to file a complaint. Complaints of housing discrimination must be filed within 1 year of the alleged unlawful incident. The first step to filing a complaint is to initiate an online inquiry using the form on our website, mccr.maryland.gov. You may also contact us by phone, 800-637-6247 or 410-767-8600, Maryland Relay 711. Intake. The intake unit will contact you to schedule an interview, either by phone or in person, with one of our trained intake officers to complete the process. You must complete the interview and sign and return any and all necessary documents, including the charge of discrimination, to the Maryland Commission on Civil Rights before the complaint is officially filed. Charge investigation. Once a case is assigned for investigation, the investigator will conduct an impartial investigation to determine the facts through interviewing witnesses, gathering and analyzing documents, conducting on-site visits, and conducting fact-finding conferences. Voluntary resolution. MCCR offers parties many opportunities to resolve charges of discrimination. Successfully resolving the case through one of these voluntary processes is often expedient and beneficial for both parties. Methods of resolution include settlement and conciliation. Issuance of written findings. After completing an investigation, the investigator will draft a written finding, which will clearly state the positions of the complainant and respondent relative to the allegations made in the complaint and identify the results of the investigation. Finding of probable cause. If the investigator finds that based on the gathered evidence, it appears that there is probable cause to believe that the complainant was discriminated against, the investigator will take the necessary steps to resolve the matter. MCCR staff is responsible for making a good faith effort to conciliate these matters. Conciliation efforts focus on bringing the discriminatory practice or policy into compliance with the law and providing full remedy and relief for the complainant. However, if conciliatory efforts fail, the case will be forwarded to the Commission's Office of the General Counsel. Finding of no probable cause. If the investigator finds that based on the submitted evidence that there is no probable cause to believe that the complainant was discriminated against, a written finding of no probable cause will be issued, and the case will be subsequently dismissed. The complainant then will have 15 days to file a written request for reconsideration to the Commission's Deputy Director. Once the Deputy Director has reviewed the complainant's request, a decision will be made to either uphold the finding issued by the investigator or remand the case back to the investigator for further investigation. Education and outreach. The Maryland Commission on Civil Rights provides outreach services, information, and training support to agencies and individuals in Maryland on issues affecting equal access and opportunity. Through our community outreach and education program, we offer workshops and seminars to institutions, businesses, and organizations throughout the state. We look forward to working with you to accomplish our vision to have a state that is free from any trace of unlawful discrimination.